while the arguments are occurring, don't come back in. We're going to be here for at least another hour to an hour and a half. If you don't think that you can wait that long, or if you're comfortable sitting that long, let me ask you to leave now. These are public proceedings, but they're under very strict conditions, and I don't want these discussions, these arguments, this critical phase to be interrupted by people that keep on going in and out of the courtroom. And I didn't want to bring it to the attention when the state was making the argument, because then that would just get the jury to focus in on that problem. But as soon as we bring this jury in, you are here in this courtroom until there is a break in the discussion. Please understand that. If you feel you cannot comply with that directive, let me ask you to stick. Then go ahead and leave, and then you can come back in while we have the next recess. Let's go ahead and bring the jury in.
Rise with the jury. Yes, we're ready to proceed with the defendant's closing argument.
Thank you. May I stand for the Alamo?
Yes, of course.
Thank you, sir.
Tai Chan is not guilty of first-degree murder. Tai Chan is not guilty of second-degree murder. Tai Chan is not guilty of voluntary manslaughter. Tai Chan acted in self-defense on that night in October of 2014. No matter how hard Mr. Clark and I fight, no matter how hard we push against this investigation, this case brought by the state on faulty work by police officers, on missing evidence, on things that were not tested, on things that were not done, on things that were done just a couple of days ago while we were in the middle of trial, on things that are missing, on holes in their theory, on gaps in their case, on mistakes, errors, sloppiness. No matter how hard Mr. Clark and I push back against that, the burden here never changes. The burden is always on the state government of New Mexico to come in here and prove beyond a reasonable doubt that Tai Chan did not act in self-defense. And they haven't done it. Tai Chan does not have to prove anything to you. The state of New Mexico has to prove to you the things that the judge told you, and you will see in the instructions what the state has to prove. And first and foremost, they have to prove to you that Tai did not act in self-defense. And they haven't done it, and they cannot do it. The American criminal justice system is admired all over the world. It's admired for the protections that it gives each and every one of us as citizens. It protects each and every one of us should we ever find ourselves in the chair that Tai Chan is sitting in today as a man who acted to preserve his own life, to defend his own life, accused of these crimes that he did not commit because he acted to defend himself. At the heart of our system of American justice is the jury. No one is more important to our system than the members of the jury. You are the people who are entrusted with ensuring that someone sitting in the chair where Tai Chan is sitting is afforded the protections that we've talked about, that the judge talked about, that we all understand, whether it's from TV or movies or sitting here, but we all understand what protections we have as American citizens. In one respect, your job is extremely difficult because you are given a responsibility that most people will never know. You hold the life of a man in your hands. You will decide the fate of another human being. That's a grave responsibility, and it makes your job a difficult one. And yet, in another way, your job is easier because you were not asked to figure out what happened in this case. You were not asked to determine whether Mr. Chan is innocent. You're only asked to determine whether the lawyers for the state government of New Mexico have convinced you beyond a reasonable doubt that Mr. Chan did the things he is accused of, and have convinced you beyond a reasonable doubt that he did not act in self-defense that night. He did not act to defend himself. He did not act to preserve his own safety from death or great bodily injury. And if you have uncertainty, and if you feel like you're not sure, and if there are unanswered questions, and if those questions keep you from feeling confident about what happened, your job is easy. You must find Tai Chan not guilty. We're going to look at the evidence in this case more closely. Before we do that, I need to take a moment to discuss some of these important legal principles that you have heard in the last 2 weeks and that you have seen in action. I mean, we all learn in school about the Constitution and what that means and what that document means, but what you have done in these last 2 weeks is take those little booklets of the Constitution that we used to get in school and read through, and you've actually used that and applied it, and you've seen it at work, and you've seen it in action, and you've had a chance to see what do all those words mean? What do all those protections mean? Whether it's the New Mexico Constitution or the United States Constitution, how does that work? How does that affect someone in real life? And you have seen that. And what you've seen is that the Constitution, both the New Mexico Constitution, which is a beautiful document, that came into existence at the time of statehood in 1912 and the United States Constitution from 1789 are like this wall protecting us from the excesses and the mistakes and the errors of our government. And that's what they meant back in 1789, and that's what they meant in 1912. And the problem is when the state of New Mexico brings a case, a criminal case, and that case is full of holes and mistakes and errors and things that should have been done and things that should have been tested. And I wish we could have done that, and we should have done that, and we had to do this 2 days into the trial. We had to do this 4 days into the trial, and we didn't do that. What that is like, it's like you knock a hole, you take a brick out of that wall, and you take 6 bricks out of that wall, and you take 25 bricks out of the wall, and it weakens the wall. And so what we have is this Constitution that protects us from the excesses of the government and the mistakes of the government, but if we let them knock holes in the wall through their faulty investigations and their incomplete investigations and the mistakes and the errors and the things they didn't do and the things we wish they had done, if we let them knock those holes in the wall is weak and it crumbles, and it could be our neighbors next time who are sitting in that chair charged with crimes because they defended themselves. You heard about the presumption of innocence. We talked about that in voir dire. You've heard these concepts. What does that mean? Well, the presumption of innocence is like in olden days, people used to wear these things called cloaks, right? It was something you'd wear if you're riding a horse or in a wagon. It was something you wore to protect yourself against the elements. It's like, as American citizens, we have a cloak of innocence that protects us should we ever be falsely accused of a crime or accused of something because we acted to defend ourselves. That cloak of innocence can't be removed unless and until the lawyers for the state government of New Mexico meet a very, very high burden. And it's a burden that the state hasn't met in this case. But that cloak I'm talking about, the cloak of protection that protects each of us if and when we or our neighbors or our cousins are accused of something when we've acted in self-defense, it doesn't work unless every member of our community believes in that principle, in that idea that the cloak protects us. When you were sworn in as jurors, each of you agreed to honor this principle. Each of you took an oath that you would honor the Constitution, both of New Mexico and of the United States. And by doing that, you agreed to view Mr. Chan as an innocent man at the outset of the case. And you agreed to hold that view as long as you listened to the evidence in this case. And you agreed that you would not take that cloak of innocence off of Mr. Chan's shoulders until you had decided that the state government had met its very, very high burden. And as you listen to these final arguments today, you must continue to presume that Tai Chan is innocent. You must do this as you hold the state of New Mexico to the standard that's required by the laws of our state and of our nation. Now, the next important principle we talked about at the outset of this trial is the burden of proof. And you will get instructions, the instructions that the judge read to you. You will have those in your hands. You can read them, and you have to follow those instructions. That is the essence of your job once we finish with these arguments. And your job is to go into the room and consider the evidence and deliberate. And you will have the instructions, and we're going to go over them in a minute. What the instructions say is what we've been talking about. We do not require anyone to prove their innocence. Our system insists that before the state can take away someone's liberty, the state bears the entire burden of proving the accusations against the person. And what does that mean? Well, it means if you have any questions at the end of the trial, at the end of the day, you cannot look for the answers to the defense, to Tai Chan, because it's the responsibility, it was the responsibility of the state to answer the questions for you. And the state's failure to do so, the state's mistakes, the problems, the things that should have been done that weren't done, the things that they wish they had done now, that's the basis for a not guilty verdict in this case. So if you wanted to hear from someone else as a witness, you can't look to Tai Chan to answer that question. If you wanted to hear something else or see some other evidence, you can't look to us to provide the answers, because that's, as you'll see in the instructions given to you, that's not what you do. You look to the state to answer the questions. And if you feel that the state has not sufficiently done its job, and if you feel that the state has not answered its questions and your questions, you cannot hold that against Mr. Chan. Our Constitution, both the New Mexico Constitution and the United States Constitution, allow Mr. Chan to sit back and make the state prove its case against him. He's not required to present evidence. He could sit back and let the state do what it can to meet its burden. But he chose to take the stand and sit in this box and face you and look in your eyes and tell you what happened. And you got to see him, and you got to look him in the face, and you got to hear the words that he told you. He did not have to do that. But you needed to hear from him what happened. You needed to hear from him that he felt that his life was in danger, and you needed to hear from him exactly why he did what he did that night. In a criminal case, you may think that the accused probably committed the offense. That's not enough. You may believe that someone who's accused likely committed a crime. That's not enough. You might even feel fairly certain that the person who is sitting there committed a crime, and that's not enough. In each of those scenarios, you have to find that person not guilty, because you may only return a verdict of guilty if you find proof beyond a reasonable doubt. Well, what is that concept? And I've been trying cases for 25 years, and I think that is something that we need to discuss, because beyond a reasonable doubt is not a concept that every one of us deals with every day. Or maybe you think you don't deal with it, but actually I will tell you that you do deal with it every day. I'd like you to ponder this for a minute. If your spouse, for example, had a serious heart condition and you walked into Dr. Smith's office to find out what you should do, and you notice Dr. Smith has bedding slips from a horse track fallen out of his white lab coat, and you notice that on his desk is a message from his wife saying, "We haven't paid the rent in 6 months. What are we going to do about it?" And then Dr. Smith comes in and checks out your spouse, your wife, or your husband, and he tells you that your spouse needs an incredibly expensive procedure to save her life. And Dr. Smith says, you got to have that procedure right away if you want to save her life. And by the way, I need that payment right now before I begin the operation. And you put all those facts together in your mind and you're thinking, do I have second thoughts about letting Dr. Smith operate on my wife after I immediately give him all this money? Do you seek a second opinion? Well, of course you do. And of course you have second thoughts about letting Dr. Smith operate on your beloved wife. Well, I'll tell you that Tai Chan's life depends on how much you trust the word of Dr. Smith. It's the same concept. Just as Dr. Smith's word would not be good enough for you when you're trying to save your spouse, you should be equally troubled about the facts of this case when you're trying to decide the fate of Tai. The jury instructions that the judge read to you, those are the rules that you will take back into the jury room and work from. There is an instruction, as the judge read to you, for first-degree murder. And this is the instruction. Now, and you will hold this in your hands, and you can read this when you're in the deliberating. It says, for you to find the defendant guilty of first-degree murder by a deliberate killing, as charged in count 1 of the indictment, the state must prove to your satisfaction, beyond a reasonable doubt, each of the following elements of the crime. 1, the defendant killed Jeremy Martin. 2, the killing was with the deliberate intention to take away the life of Jeremy Martin. 3, the defendant did not act in self-defense. 4, the defendant was not intoxicated from the use of alcohol or drugs at the time the offense was committed to the extent of being incapable of forming the intent to take away the life of another. And down below it says, deliberate means arrived at or determined upon a result of careful thought and the weighing of the consideration for and against the proposed course of action. Now, I'll tell you that the lawyer for the state wants you to buy the idea that this is first-degree murder. And I tell you that by telling you that, the lawyer for the state is challenging your belief in what you heard. And it's overreaching. And it doesn't fit the facts. And they did not have enough respect for what happened here in the last 2 weeks to tell you this is not first-degree murder. And you know it's not first-degree murder. And you know why. And the reason that we know that they are even conceding that this is not first-degree murder, the state is conceding it, because every time they brought up a hypothetical situation with a witness, the facts that they used were, well, okay, what if it was two guys fighting in the room and there was a fight and one of them got punched in the face? Every single hypothetical that the state brought up was not about first-degree murder or second-degree murder, and we will get to that. But there is no first-degree murder here. There is no careful planning and preparation and thought in what happened that night. And the fact is, every single one of their police witnesses who made contact with Tai Chan said, yeah, he seemed intoxicated to me. He seemed intoxicated. The witnesses at the bars. You heard Dr. Marchinsky, who the lawyers for the state did not like her. They did not like her testimony because it was troubling to them that she could help show the level of intoxication and help show how people act under the influence both of the energy drink, Red Bull, and vodka, and the alcohol in the vodka. So I ask you to remember that. The jury instruction for first-degree murder, deliberate intention, careful thought, and the weighing of the consideration for and against the proposed course of action. It's not here. Again, it's overreaching by the state. It's asking you to believe something that's not present, that's not there. And I would say, as jurors, you sat here and listened to the evidence, and you know that's not there. And for them to come in here and say, go way beyond what you saw. Go for first-degree murder. It's not first-degree murder. But they're asking you to buy into that fairy tale. And the problem with that is that it doesn't fit with what you saw with your own eyes and heard with your own ears. And each one of you knows what evidence was presented. And no matter how hard people try to shade the evidence and convince you that you saw something you didn't see or hear something you didn't hear, you know what you saw and you know what you heard, and you know there was no careful thought in the weighing of the consideration for and against, no planning, no preparation, and you know the level of intoxication both of Tai Chan and Jeremy Martin, and you know that Tai Chan, from his own mouth, told you he acted in self-defense, and they have not brought anybody in here to tell you otherwise, because Tai Chan's testimony is what we call uncontroverted, meaning no one came in here and said that's not what happened. And if they had that, they had to present it to you. They didn't. Uncontroverted evidence is what that is. The last line of that jury instruction says, to constitute a deliberate killing, the slayer must weigh and consider the question of killing and his reasons for and against such a choice. Clearly it didn't happen here. Clearly the state has conceded that in their own hypotheticals, in their own argument, talking about a fight, Tai Chan getting assaulted, Tai Chan acting to defend himself. When the state lawyers, even in hypotheticals, say, okay, this is what happened. That's what they're telling you. This is what happened. It was not first-degree murder. Second-degree murder, that instruction says, for you to find Tai Chan guilty of second-degree murder, a lesser included offense, as charged in count 1, the state must prove to your satisfaction beyond a reasonable doubt. Again, that's that Dr. Smith story I was telling you. Each of the following elements of the crime: the defendant killed Jeremy Martin. The defendant knew that his acts created a strong probability of death or great bodily harm to Jeremy Martin. The defendant did not act as a result of sufficient provocation. The defendant did not act in self-defense. Now, the classic example of second-degree murder, that's if I'm angry at Tom Clark for something he did and I just strangle him out of the blue, or if you come home, a classic example of second-degree murder, you come home and you find your spouse in bed with another person and you shoot one of them. Classic example of second-degree murder. There's no planning. There's no preparation. You're acting rashly and in the moment. That's where you get this number 3. The defendant did not act as a result of sufficient provocation, and the defendant did not act in self-defense. But you heard from Tai Chan he did act in self-defense. And you heard from Tai Chan about the fight in the small hotel room, and you heard from the neighbors, and we'll get to that in a minute too. But the reason we know the state has conceded this is not second defense is, again, it gets back to their hypothetical questions that they were asking each witness. Well, okay, let's assume this was a fight between two men and one of them punched the other. That was what they kept going back to. That was their fallback hypothetical. And we all know from reading this, and you'll have more time to sit with the instruction and look at it, that it's not second-degree murder. And you can cross that off the list because of the sentence that reads, the defendant did not act as a result of sufficient provocation, and the defendant did not act in self-defense. So you know from what you've seen, this is not second-degree murder either. Now, voluntary manslaughter. Once you go down the list in the jury room and you say this was not first-degree murder and this was not second-degree murder, then you have to consider voluntary manslaughter. And I will tell you, and Mr. Clark will tell you, that this case is simply a matter of, is this voluntary manslaughter, or is Tai Chan not guilty because he acted in self-defense? That's all this boils down to. And I will tell you that. And they wouldn't tell you that because they have their hopes up that you were not listening, that you're not paying attention, that they can, with their faulty investigation and the things they left out and the things they didn't do, they're hoping that you were not paying attention, that you were not listening to what the witnesses were saying, and that you buy the smokescreen that somehow this is first-degree murder, the fairy tale that somehow this is second-degree murder. This comes down to a simple issue, and you know it because you were there and you saw the evidence, you heard the testimony. This boils down to, was this voluntary manslaughter, or is Tai Chan not guilty by reason of self-defense? That's what this case is about. The language on the voluntary manslaughter instruction, which you will get, and you will read this, and you will read it carefully, I know. The state must prove to your satisfaction beyond a reasonable doubt each of the following elements. The defendant killed Jeremy Martin. The defendant knew that his acts created a strong probability of death or great bodily harm to Jeremy Martin. The defendant acted as a result of sufficient provocation. Again, that's the difference in second. That's why it's not second. The defendant acted as a result of sufficient provocation. The defendant did not act in self-defense. And the bottom part of that instruction that you'll read says, in second-degree murder, the defendant kills without having been sufficiently provoked, that is, without sufficient provocation. As the judge told you, in the case of voluntary manslaughter, the defendant kills after having been sufficiently provoked, that is, as a result of sufficient provocation. Sufficient provocation reduces second-degree murder to voluntary manslaughter. But it is up to the state to prove to you beyond a reasonable doubt that Tai Chan did not act in self-defense. And they cannot do it. This next instruction is called the self-defense instruction. And your careful reading of this in the jury room, your careful consideration, your careful pondering on this is at the heart of this case. The instruction reads, evidence has been presented that the defendant killed Jeremy Martin in self-defense. The killing is in self-defense if there was an appearance of immediate danger of death or great bodily harm to the defendant, to Tai Chan, as a result of an assault by Jeremy Martin, and the defendant was in fact put in fear by the apparent danger of immediate death or great bodily harm and killed Jeremy Martin because of that fear, and a reasonable person in the same circumstances as the defendant would have acted as the defendant did. In this language, on the last paragraph, I ask you to listen carefully now and read carefully later. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. If you have a reasonable doubt that the defendant did not act as to whether the defendant acted in self-defense, if you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. The burden is on the state. They have to prove to you beyond a reasonable doubt that when you looked at Tai Chan, when he sat in that chair and faced you and told you what happened, the burden is on the state to prove beyond a reasonable doubt that he did not act in self-defense, and they have not, and they cannot do it. There is an instruction that we all know as the stand your ground instruction. And what that means is any of us who know someone, who have a neighbor, a relative, anyone who has acted to defend themselves against a threat, who has said, I'm not going to run away, I have a right to defend myself, my neighbor has a right to defend herself, you don't have to give in to threats. This is at the heart of that issue. This instruction that you will have and you will read, and I ask you to look at this just as carefully as the self-defense instruction. This one reads, a person who is threatened with an attack need not retreat. In the exercise of his right of self-defense, he may stand his ground and defend himself. So we all know, you know as well as I do, that what this case is about is whether Tai Chan used reasonable force that night to defend himself. And how do we arrive at that answer? Well, I will tell you that we have shown that he was defending himself, but again, that's not the standard. It's for you to make the determination of whether the state government has or has not proved their burden beyond a reasonable doubt. And there have been a lot of witnesses that you've heard in the last 2 weeks. Not all of them have been necessarily pertinent, but I will tell you the ones with first-hand information are the ones that I ask you to pay the closest attention to. There are some witnesses that in closing argument that the state didn't address, and I would like to do that with you. Ian Robles, you remember Mr. Robles, who flew in here from Austin. He knew Tai Chan, met him a couple times, was the designated driver that night, was not drinking anything because he had to work the next day. He had a clear head. He's friends with Josh, Sex Hour, who you remember. But Mr. Robles had some observations that I ask you to pay attention to because, again, he's a young man, he's getting his MBA, he has to work, he decides, I'm not going to consume any alcohol because I'm the driver and I have to get up early. So he's paying attention to what's going on. And the first thing he notices is when Tai Chan and Jeremy Martin get in the car, that Jeremy Martin immediately begins what Mr. Robles noticed throughout the night, which was this needling of Tai Chan. First thing he says is, oh, Tai Chan just came out in a bar he's a faggot. He came out in a bar and he's a fag. That's how Jeremy Martin's encounter with Ian Robles begins. And it proceeds on with Ian Robles noting that throughout the night, as he told you, Jeremy Martin was needling Tai, and Jeremy Martin seemingly got upset over things and slammed his water glass down and walked away, and that Tai Chan was worried about Jeremy, and Tai Chan was saying, he just can't take a joke, I'm really worried, I need to find Jeremy. And Ian Robles told you that he thought something had been brewing, and at one point he thought something might get physical, but Tai got up and walked away and diffused whatever that was. And when Jeremy also walked away, and when Jeremy came back, Tai Chan says, hey, are we cool? Are we cool? And Jeremy says, I'm cool. I think I'm pretty cool. And Tai says, are we cool? And Jeremy says, I'm pretty cool. I don't know about you. And Ian Robles hears Tai say at another time, I would never doubt that you're a good cop. I think you're a good cop. I would never blame anything on you. You remember, these are the statements that Ian Robles gave to the police right after the shooting that next morning. And Ian Robles also says at one point, he says to Jeremy, you've been needling Tai all night and he's taking it. I think you ought to do the same. That's Ian Robles' perception of what's going on in that dynamic. Ian picks up on the fact that Jeremy Martin is needling Tai. Jeremy Martin is upset about something. Ian Robles, who's not drinking, who's not participating, he's observing, he has to work the next morning. He's a witness, I would say, who has the credibility that you can listen to and you can trust, because what he told you was exactly what he told the police after that night. And Ian says, whenever it was said between the two of them, they made up at that point, and when they left, things seemed okay. But Ian picked up on the tension, and he picked up on the source of the tension, which was Jeremy Martin saying to someone he'd never met before, Ty's a fag. Ty came out of the closet, he's a faggot, needling him, that low-level, aggressive behavior that seems inexplicable and unexplainable now, but is significant when we look at what happened that night. Josh Sexauer, you heard Josh on the stand, a close friend of Ty's, someone who was there that night, who said he thought that Jeremy was being an ass, and that was his word. And you can judge Josh's credibility and the way he testified to you and what he said. And as with Ian Robles, I believe you will find Josh credible, believable about what happened. The lawyers for the state, but I would ask you to focus in on the areas where the lawyers for the state have attacked people, have attacked witnesses and their credibility, because that's how you know what is most harmful to their case. It's a roadmap backward to what they're most concerned about proving and what's the dangers are for them, because they have a very bad case. They attacked Leah Tafoya's testimony. Leah, who is on the phone with Ty, Leah, who hears Ty say, he punched me in the mouth and he kicked me in the testicles. It's a statement that Leah hears Ty make about Jeremy Martin, and she doesn't know what's going on, and it sounds crazy, what's happening. But note that they spent time attacking Leah because what Leah says hurts their case, and they want you to ignore the things that hurt their case. Leah hears what we know as Ty in the bathroom on the phone, Open the fucking door. Jeremy Martin, aggressive, banging on the door. That's what Leah hears. That's what she tells you. What's uncontroverted. In other words, no one has come in. The state has brought in no one to say that's not true. That's not what happened. It's uncontroverted evidence that you take back to the jury room. And what you heard was Leah say, I believed it was Ty who said, please no, because why else would she have thought he was dead? Why else would she have started screaming and burst into tears, as she told you? And the state wants to undermine that. They want to attack her. They want you to disbelieve it because it hurts them, and that's how you know, following the roadmap back to the problems with their case, the problems they have in proving this beyond a reasonable doubt. Note who they attacked. Note where their attacks went. Note how vehement, how strong they were in trying to undermine witnesses who hurt them the most. Now, another witness they did not like was Dr. Trumpeter. Dr. Trumpeter, you know you are the judges of these experts, but Dr. Trumpeter, a board-certified police psychologist, a man who works with police officers, with police agencies, who goes out on calls, who debriefs officers hundreds of times after critical incidents. Dr. Trumpeter, who came in here from Modesto, California, and sat on that witness stand and answered your questions, answered our questions. He told you, in his view, it sure seemed like Ty perceived a deadly threat, given the facts, given the situation, given the gun, given all the evidence, that a police officer who perceives a deadly threat is trained to do certain things. And one of them is neutralize the threat. Dr. Trumpeter talked about how fast shootings take place, why people seem to be shot in the back, why officers react with muscle memory, with doing what they're trained to do, even if they are intoxicated. An officer's training kicks in and they neutralize the threat. Dr. Trumpeter sat on the witness stand and told you about his experience, hundreds and hundreds and hundreds of police officers in these types of situations. And he applied what he does with on-duty officers to the facts of this case. Then you be the judges of what you thought of Dr. Trumpeter. But I will tell you, he is a psychologist with police departments who has extensive experience. And if he tells you it sure seemed like that was perceiving a deadly threat, I would ask you to consider what Dr. Trumpeter said carefully. Dr. Marchinsky, and they did not like Dr. Marchinsky, and they did not like what she had to say, but she stuck to her work. She stuck to her opinions in light of the questioning and the scorn, because she's a professor at Northern Kentucky, someone who has spent a career studying the effects of the energy drink and alcohol. And Dr. Marchinsky could tell you, you know what, even if you're intoxicated, even if you're at 0.24 or 0.21 or whatever the alcohol level was, if you are faced with, what you can take from her testimony is, if you're faced with a deadly threat, remember she talked about the lower part of our brain, the part that kicks in to preserve our lives. You don't need the frontal lobes functioning if you're that intoxicated. But if you have to defend yourself, said Dr. Marchinsky, someone who is intoxicated could do it and would do it, because that's the lower brain kicking in. If I don't do this, something horrible is going to happen to me. And again, that did not sit well with the state because it undermines the fairy tale about what they believe happened. But it's what Dr. Marchinsky said, and she's the one who's done the studies. She's the one who's done the professional work. She's the one who came in here and looked you in the eyes and said, this is what I found, and this is what's possible. Again, something that the lawyers for the state of New Mexico hammered again and again was that Tai Chan, somehow because he'd gone up the several steps in the stairwell, because he followed the directions to walk down backward, that somehow that meant that he was faking the intoxication. I'm not sure, because there's so many confusing things about what the lawyers for the state have told us, but I think that's what they're saying, is that someone who's intoxicated can't come down several stairs under the orders of a police officer. And in fact, Dr. Marchinsky said, when you've had that much Red Bull and vodka, what happens is your motor skills, the Red Bull energy drink, whatever's in those things, your motor skills are actually much better than someone who's just drinking the alcohol alone. And you can perform better, and it's because of whatever the caffeine and the secret ingredients and these drinks that she studied. I mean, she told us that because of her work, the federal government has said, we're banning certain drinks that are just way too dangerous. And that's her work. That's the basis for that. And so when she tells you how your motor skills operate under the influence of that, I would say take their argument with a grain of salt that he could not have walked down backward under the directions of the police officers. He did it, and all the police officers who came in here told us that he did it, but he seemed intoxicated. That's what everybody said. Officer Cosper, Bainey, everybody who had contact with him said he seemed intoxicated. So Dr. Marchinsky answers some questions for you. And you're the judges of her. You're the judges of her credibility and her skills and her experience. But I would ask that you remember what she told you and what the basis for her opinions were. And consider that carefully. Same with Dr. Trumpeter. These are experts who knew what they were talking about, and despite the efforts by the lawyers for the state of New Mexico to undermine them, to attack them, to heap scorn on their opinions, at the end of the day and in the final analysis, they could not defeat Dr. Marchinsky and Dr. Trumpeter. The state lawyers did put a lot of emphasis on Marvin Zamora. I would just ask you to remember Mr. Zamora sitting here. The way that worked was in time, right after the shooting, he gave two statements, one to the police officer and one he wrote out for his employer. Those two statements, the first two statements were identical. This is what I saw. We heard shots. We saw someone running down the hallway. We got out of there as fast as we could. And that's believable, because if that's what you think is happening, if you think someone's been shot, you're not going to go investigate. You're going to do what he did. So his first two statements were honest. I turned and ran. If he had seen, as he told us 18 months later, well, I turned around a corner, I went down there to see, and then I saw Tai Chan running and shooting, and whatever he said he saw. I will tell you that immediately after an incident 18 months ago, that's when your mind is fresh. That's when you are telling someone, this is what I saw. If you had seen the shooter, he would have, first thing out of his mouth to the police detective, I saw the guy, and this is what he was doing, and this is what he looked like. If you're writing a report for your boss, I saw the guy, I saw the shooter, and this is what he looked like, and this is what he was doing. Because that's something that doesn't happen every day, and that's a remarkable event, and that's something that, if it happened, you would be relaying that to your boss, to the police, to your best friend. You would be saying, I saw the guy. But instead what he said was, I saw a person who had been shot, I didn't see anything else, and we got out of there as fast as we could. That's the credible statement. In fact, two credible statements because it happened right after the incident. So I would just ask you to remember that 18 months later, Mr. Zamora wants to, for whatever reason, he wants to solve a crime. He wants to be helpful. He wants to tell people what they want to hear. That's very human. We don't blame him for that. But I would just ask you as the judges of the fact in this case, what is more credible and what is more believable? A statement you gave immediately after you've perceived something, both to a police detective and in a statement you've written out for your employer, versus 18 months later when you've had time to talk to people and look at things and, hey, this is a better story if I tell it this way. I mean, that's sort of the idea of storytelling. With time, stories change, but what's credible and what's believable is what happened right after the fact. And again, the same thing applies to Mr. Venegas, who is the bartender who is now undergoing, he's a police cadet, and he even told you, yeah, I've learned how to make my stories better 18 months later. He's the one who said that Tai Chan was clenching his fists and he had the death stare. Remember that? He talked about the death stare. Mr. Venegas was tending bar. He was busy. He never told anyone anything about that. In fact, what he told the police was, that was just like an argument I've had with my mom. Nothing about the death stare. Nothing about clenched fists. And if anyone had seen that, you know that Ian Robles would have said that. You know that anyone who was there, Josh, Nicole, that's what they would have remembered. And that they don't remember. It didn't happen. That's why you didn't hear anything more about it except for Mr. Venegas, who, as he told you, he's in the police academy. You learn how to make your stories a little bit better. He wants to help. He wants to help the people that he's going to go work for eventually. That's okay. It's human. 18 months later to come up with these facts that didn't exist before. I mean, I think we can all excuse that. It's simply embellishing, and it didn't happen. Again, Marvin Zamora, not a bad person at all, just not credible. Mr. Venegas, not credible. You know how the paths that their stories have taken since that day. The thing to do is look at what they said right away, because we all know from life experience that the first thing you say after you witness an event is the most credible, not after 18 months of thinking and thinking and thinking. Again, you know, Dr. Trompeter told us that the world we live in, where cops are embattled and they're under fire, and we all know about that. When they go to work, they think, Dr. Trompeter said, that this day could be their last, and they get this information from the beginning of their training, and they're trained to self-preservation. They're trained to go home at the end of the day, and officer after officer told us that. And in the case of law enforcement being embattled, now these are women and men who were trained in a manner that no other civilian is trained in. They're trained to deal with threats to themselves. They're trained, as everyone told us, they're trained to take care of a threat until it is gone. And even off duty, you're vigilant and you're watchful. So when you make your decision, we ask you, again, to be looking at the totality of the circumstances. And what you heard from Tai Chan when he testified and looked you in the eye and talked to you was that he acted in self-defense. When you're in the jury room, I ask that you consider, why is it that how do we know Tai acted in self-defense? His testimony to you, uncontroverted, again, not challenged, was that he is hit in the face and kicked in the testicles by Jeremy Martin. We have a photograph of the bed, and this was Tai Chan's bed. Even the state's expert, the very last witness, Mr. Foster, said that's Tai Chan's bed. Tai Chan's bag is over by the bed. Tai Chan's cell phone is over by the bed. Tai Chan's shoes are by the bed. And please look at this photograph when you're in the jury room and all the other photographs that show the bed. The state has acknowledged, and we all know, that the only blood in that room, the only blood on that bed is Tai Chan's blood, and he got it after he was assaulted, as the jury instruction says, assault by Jeremy Martin. And this is the aftermath of that assault. Tai Chan's blood on the comforter, pillowcase sheet. There's blood on the floor. Again, this is things that the state didn't bother to test. Blood on the phone. I don't know why. I cannot answer for you why. As an old prosecutor, I'm wondering too, why not do these things? Why not test these things? Why not test the black gunpowdery substance on Jeremy Martin's hand? Why? It's almost like an assault on the jury's job, on your intelligence, to come here and say, we didn't test all this stuff. We could have. We didn't test this. We didn't test this. We didn't test this. We didn't test this. No, we didn't do that. We could have done those things, but we didn't. Why not test the blood? They tell you that they sent it off just in the last couple days of this trial, and they want you to excuse that kind of work by a state agency. They want you to excuse that. At the same time, they're asking that this man's liberty and life be deprived based on faulty work. Why not do those tests? Why not just answer the questions? Why not fill in the gaps? Why not do what they should have done? I don't know. And they haven't told you. They've hoped that you're not paying attention and that you'll let it go. And the best example of that was Mr. Foster, who came in here. We'd been sitting in trial for 3 days before he even starts working on this case. This case has been around since October of 2014. We've been working on it. I've been working on it. Mr. Foster comes in and says, I never got this stuff. They just wanted me. What really happened was the state was panicking. They understood their case before you was in trouble. They had problems. They needed to do something fast. And what they needed to do in their mind was bring in Mr. Foster, who came in here and told you things about his investigation. As we were sitting in trial, as we were coming in here every day, he finally gets around to looking at materials. And do you remember I said, well, you went to check out the room and you went to the trajectory analysis? No, I didn't. You didn't do any kind of reenactment, no analysis, nothing? No, I didn't. And in fact, he went to the wrong room. He went to room 705. And he said, well, it's kind of the reverse of 711, so I thought that would be close enough. And I'll tell you, that's a symbol of this case for you that you can take into the jury room. That the state government is bringing to you a case that they think is just good enough, with holes, with gaps, with things missing, with things untested, and they're hoping that you are not sharp enough to see what they're doing, and they're hoping that you are not paying attention, and that you will say, well, that's fine. If Mr. Foster went to the wrong room, that's fine. If we didn't test this, that's fine. If he didn't do a trajectory analysis, that's okay. But we still want you to find Tai Chan guilty. Wouldn't we be outraged if they were doing this to our neighbors? If they were doing this to our friends and family? Wouldn't we be outraged and say, don't do that. Do a good job. Do what you're supposed to do. Don't bring in people here and say, I went to the wrong room, or we didn't test that, or we could have tested the hands. Oh, we didn't. Oh, don't worry about that. You don't have to worry about that. You don't have to worry about the black powdery substance. Don't worry about that, okay? Just please ignore that. Please ignore that and convict him. Please ignore the problems we have with our case and convict them. You'd be outraged if it was your neighbors. Your Honor, may I approach that?
Yes, go ahead.
The state brought in a woman from the DPS crime lab, and you heard her testimony about this, and you heard her testify about what she did to test it and the DNA she got off of this. And she said, yeah, Tai Chan, it was his gun, so I'm not surprised that his DNA is on the gun. But then there was another contributor, and I would ask you again to listen carefully to the scorn and the attacks that the state government lawyers put on the idea that both the DPS DNA expert and Mr. Spence, Dr. Spence, who came in here and talked to you, they both said, look, what they're saying is Jeremy Martin's DNA was on the gun. And the state wants you to say, oh, well, there could have been almost 7,000 other people who, you know, if you get 7,000 people together, someone else could have put that on. No, no. You know how Mr. Spence explained it to you, Dr. Spence. And the other thing to remember is that Jeremy Martin's DNA was also on the watch. And what are the odds? What are the odds? You know what happened. The watch came off in the fight, in the assault on Ty, and the expert for the state told us that she tested this gun. And where did she test? The answer was, well, I tested, these are her words, I tested where somebody who's holding the gun would hold the gun. The grip, trigger guard, and slide. And that's where Jeremy Martin's DNA was found. That's where Jeremy Martin's DNA was found. Where, she said, I tested where you would hold the gun if you were holding the gun, and that's where I got Jeremy Martin's DNA. That's what essentially she's saying. And they can argue all they want, and they can sit here and try to heap scorn on the idea that that was Jeremy Martin's DNA, but the problem is it was also on the watch. And the watch was in the room, on the floor, under the bed. And Tai Chan told you that when he was in the room, he sees Jeremy Martin, and he's got a gun. Now, could Tai have been wrong about what hand it was in? Yes, it could have been. We don't know. And you know that. But what did you hear? You heard that officers are trained to shoot with left or right hands. You heard that Jeremy Martin had the bruising on his knuckles and the powder on his palm and fingers. And the state made a lot of effort to put up a smoke screen and say, well, that couldn't have come from that. It was from some other. Again, this was stuff they didn't test. They could have swabbed the hands. They could have tested the black powder. They didn't. They're in here today asking you to just ignore those things. Ignore them. You can't. But what do we know? Uncontroverted evidence, black powder on the left hand, the bruising on the right hand, Tai Chan's blood on the bed from being hit in the face by Jeremy Martin with his right hand. And Ty's recollection is Jeremy had the gun in his left hand. Ty was there. He's telling you what he recalls. If it's imperfect, it's imperfect, but that's what he told you. And the bullet hole in the ceiling, where we have this, we even have the section of the ceiling that they pulled out. But again, they didn't do trajectories. They didn't go in there with the lasers and the rods and the lines because they're hoping that was just good enough. Everybody agreed that was a 45-degree angle. And I think from what we've heard, you can understand that the first shot into the ceiling from that Glock pistol was the shot that Ty told you Jeremy fired at him. The shot that Jeremy fired at him, 45 degrees into the ceiling. The bullet casing goes across the room. Everybody agreed. Everybody agreed who knew about this that that shot could have come from the bed. Ty's testimony is he's being hit in the face. That's where the blood comes from. I mean, the state has not told you anywhere else the blood could have come from. Today, an argument, and again, argument is not evidence. Today, The lawyer for the state government said, well, he was standing over the bed dripping. And that defies belief because we know how fast these things were happening. The general consistency of the hotel guests is amazing. They hear a number of shots. The sequence, we don't know what the sequence was. These are people who told you they were being awakened out of a sleep by what sounds like, in one witness's words, a drunken fraternity party, an argument, furniture crashing. This is happening quickly. It's happening fast. They'd hear a number of shots. No one remembers the exact same sequence. No one remembers the number of shots exactly. But what seems consistent is they heard a fight, they heard a struggle, they heard the banging, the crashing, bodies against the wall. Every one of them, without exception, is consistent about the level of confrontation in room 711. And there may be a varying degree of perception because people are at different locations in the hallway and different locations from the room. But what they heard was the crashing and the banging and the words, "Get the fuck out of here." What does that mean? Who said it? We don't know. It's not up to us to prove it. It's up to the state to prove beyond a reasonable doubt that Tai Chan did not act in self-defense after this crashing and the banging. And as Tai told you, Jeremy had that gun in his hand, and that gun has Jeremy's DNA on it. And that watch that Tai had that was ripped off in the struggle, that watch had Jeremy's DNA on it. And Tai's blood is on the bed, and the bed is messed up, and there's a shell casing across the room, and there's a bullet hole in the ceiling at a 45-degree angle. And their witnesses said it could have come from the bed area. There was a very, very serious confrontation in the room that's consistent with all the physical evidence. And these witnesses, without exception, the police witnesses and the hotel witnesses told you consistently that what happened in that room was a very serious struggle. And even the first officer in the scene thought that someone had been shot on that bed, and that's where a shooting took place, because there was so much blood. What happened after the shooting? Well, that is, you have testimony that what happened, consistent testimony, the same level of consistency, what happened after the shooting. And I would point to you, to Mr. Bravo, Erasmo Bravo, a warden in the penitentiary system, a trained law enforcement officer. He knows guns. I think we can all assume he's got a certain level of training and experience, and he can react to situations. And what does he tell us? He says, I opened the door and I saw what he thinks now is Tai Chan holding a gun. And what does Tai Chan tell Mr. Bravo? Call the police, call the police, call the police, call 911 before Mr. Bravo closes the door. Those are not the actions of someone who committed first-degree murder. Those are not the actions of someone who committed second-degree murder. And those are not the actions of someone who committed voluntary manslaughter. It's the actions of someone who acted in self-defense and is pleading for help. Mr. Bravo told us that. It's like someone was begging for help. Get me help. Get help. Call the police. Call 911. And you heard the lawyers for the state try to pitch this idea to you that somehow Tai Chan was unconcerned after the shooting, was not caring, was not trying to get help, was not trying to protect the public safety. All you have to do is remember what Mr. Bravo said when he was sitting here talking to us, and he said, yes, he said 3 times, call the police, call the police, call the police, call 911. Get help. Help me. Help. You heard the words in this last 2 weeks about a rush to judgment. What did the police do in this case? Now, Ms. Paulos is a nice enough lady. She told you she had not been involved in very many homicides. This was the second one she was a case agent on. And it's evident that there were things that were not done in this case. And it's very clear to me, this is not an attack or an indictment of the police department by any means. But mistakes were made. And that became evident in this case when the state was forced to go send that important piece of evidence, which was a comforter, that white comforter that we've seen the pictures of. We were on the 7th or 8th day of trial, and they decided to send that to get tested. That's when they decided to send it to get tested, not in the preceding 18 months when we've been working on this, when things have gone back and forth to the lab. Suddenly it's important to get this tested. And it comes back, and yes, it's nothing but Tai Chan's blood. What is this telling you about the nature of this investigation and things that weren't done? What did they also not do? Well, they told you this. They didn't test hands. They didn't look for fingernail. They didn't go under Jeremy Martin's fingernails to look for DNA of Tai Chan. They didn't swab the hands. The state made a lot of effort to try to say, well, we don't swab hands. That's not something we do. Well, Ms. Paulus told you they could do it. And wouldn't that answer some questions to you about whether Jeremy Martin had fired the gun? I mean, what you have is the black gunpowdery substance on his palm, but they didn't test that either. No fingernail testing, no hand swabs. Sending evidence at the last minute, bringing in an expert witness who said, I didn't do I didn't have enough time, I didn't do the trajectory analysis, and besides I went to the wrong room. Well, what is the value of that missing information? Tai Chan told you on the witness stand that Jeremy Martin shot first. Wouldn't you want to know, do the hand swabs show that Jeremy fired a handgun? An important question that they didn't answer because they didn't test it. So you have Ty's testimony that Jeremy Martin fired that shot and he thought his life was in danger. But it's uncontroverted testimony because they can't challenge it. They can ask you to guess, they can ask you to speculate, they can ask you to come up with a fantasy or some story or a tale. That's all they can do because they didn't test the hands, they didn't test the fingernails. So when the lawyer for the state gets up here and says, you can speculate here, you can speculate there, you can speculate there, you can speculate there, what they're saying to you is, we made these mistakes, we didn't do this, so please cover for us. Please cover the mistakes we made, the errors we made, and speculate. And what we're telling you is you heard and you saw the evidence. We're not asking you to speculate. We're asking you to go by what the evidence was that you heard and what was presented in the court. I ask you to consider the two different assignments that you're getting. One from the state, please guess, please fill in the blanks, please fill in the holes, please do our job for us. And what we're saying to you is, no, don't guess, don't speculate. Listen to the evidence. Look what you saw. Remember what you heard. Remember what Ty told you. Remember what has been unchallenged, which is Ty's story about what happened, because that's what happened. And the state cannot tell you otherwise. They can ask you to guess, but they can't show you. And one reason they can't show you is because they didn't do these things that they should have done. And they want you to cover for them. And they want you to cover for them and convict him. First-degree murder? No, it's not first-degree murder. Second-degree murder? No. Voluntary manslaughter? No. He acted in self-defense, as he told you. He acted in self-defense. If anybody, our neighbors, our cousins, our friends, their lives were at stake and they acted in self-defense, you can imagine what would be going through our heads. You did what you had to do. And in fact, that's what Tai Chan said. And all that craziness that you heard on the tape, the 6 hours of tape condensed down to 1 hour, I ask you to listen to that in the jury room. How many times does Tai Chan say, in the midst of all that turmoil and excitement and intoxication, Tai Chan says, I acted in self-defense, I acted in self-defense, I did what I had to do. He shot at me first. He shot at me first. I ask you to count how many times he says that. The problem is that, as you heard, from the outset, from the get-go, the police believed this was a murder. And you heard them say that. You even heard them say, Well, we went to the grand jury and someone asked, was there any evidence of self-defense? Did he say anything about self-defense? No, he did not. Well, he did, and you know it because you heard it with your own ears. And that's what I mean by arrest to judgment. They assumed right from the start that there's no self-defense here because they jumped to murder. And instead of doing things that they should have done, which could have shown us, which could have answered these questions to you, they didn't do them. Again, Tai Chan says Jeremy Martin shot first. The hands, the swabbing, a lot of things could have been done to answer those questions. If they didn't answer them, you cannot hold that against Tai Chan. You hold that against the people who have the job to do. And if they don't do that job, if they leave questions unanswered, Tai Chan is not guilty. Not guilty of first-degree murder. He is not guilty of second-degree murder. He's not guilty of voluntary manslaughter because he acted to defend himself. The blood on the bed didn't matter to them. The fingernails, the hands, so many things didn't matter to the state in their rush to judgment, but they should matter to you in the jury room, and they should matter to you as jurors, and they should matter to you as people who care about the Constitution and the protections that we have under the Constitution, so that we are not, and our neighbors are not, the victims of bad, lazy police investigations. Your Honor, may I have a moment? The case agent on this case, Ms. Paulos, told you that yes, once a murder investigation is rolling down the tracks, it's really hard to stop that train. And she was being truthful because that's our real life experience with government agencies and police departments and things like that. She was telling you like it is. She was telling you the truth. It can be hard to stop a train. Once everyone has their mind made up, it's a tough thing to do. But your job is to consider carefully what you've heard and to stop that train. You've heard that Tai Chan acted in self-defense, and they cannot prove to you that he didn't, and that's the burden that they have. Once you begin deliberation, I urge you carefully and thoughtfully consider everything you've heard. Take your time because your decision is final and irrevocable. It's the job of our jurors to do this, to listen to the evidence, but you cannot, if you make a decision, you cannot call us up 2 weeks down the road and say, you know what, I made a mistake, or I'm having second thoughts. You can't do that. You can't call the judge. You can't call the lawyers and say, I made a mistake in this. It's a final decision. If you continually find yourself thinking about how Jeremy Martin's DNA is on the gun and Tai Chan's blood is on the bed and Tai Chan has the injuries to his face and Jeremy Martin has the injuries to his hand, if you find yourself thinking about it, you can't say, I want to take back a verdict. So please consider all the reasons to doubt in this case. Remember that each of you only has to have one reason to doubt, and they need not be the same reason, and I ask you to leave no stone unturned as you consider the evidence. You know that night if Tai Chan had not defended himself, we know what would have happened. If Tai Chan had not acted to defend himself, we would have buried Tai Chan, and Mr. Clark and I would be defending Jeremy Martin. As jurors, I say you need to be brave individually and be brave as a group and not fear what people might say afterward. You need to concentrate on the evidence at hand and do your duty. And you have a duty to be fearless in the administration of justice. Our jury system doesn't work unless jurors are brave and courageous. It only works when juries are fair and careful and consider the evidence. And it's your duty and your job that stands between Tai Chan and an unlawful conviction. I've been just remember one other witness that no one has talked about, and that's Ms. Hynite, who saw Jeremy Martin outside down the lobby that night. And she said he seemed excited, and he was looking for someone, he was anxious. And that's a witness no one has talked to you about yet. I've been practicing in the state for about 25 years and appearing before juries. And I had a mentor, this old lawyer named John Paternoster, who retired as a district judge up in Clayton and Raton. In his last case as a lawyer, he was a prosecutor and a defense lawyer, and just a good, solid New Mexico lawyer. In his last case as a defense lawyer, was representing an innocent man who had been charged in a murder, and the jury came back and found that man not guilty. And I admired John beyond belief. And I remember the last statement he read to the jurors before he stopped talking. And I don't know where he got it, but it stuck with me, and I wrote it down. And what he said was, "Our courts are a living, working reality. The court is no better than each of you sitting before me on this jury. And a jury is only as sound as the men and women who make it up. I believe you will review without passion the evidence you have had, come to a decision, and in this case, restore Tai Chan to his family. In the name of God, do your duty."
Thank you, Mr. Davis. We're going to take another short recess before the state proceeds to reply.
Please rise to the jury.
All right, thank you. We're in short recess.